Let's discuss duty of disclosure, candor, and good faith when it comes to applying for a U.S. patent. This duty is based on a specific United States Patent and Trademark Office rule known as Rule 56, as well as various court decisions. Rule 56 requires that anyone involved in the process of filing and prosecuting a U.S. patent application disclose to the USPTO all non-cumulative information known to be material to the patentability of the claims in that application. According to the USPTO, those involved in the process include each inventor, each attorney or agent who prepares or prosecutes the application, and anyone who is involved in the management of preparation or prosecution of the application. So, whether you're an independent or startup inventor, or you're involved at the engineering, product development, marketing, or legal level of the patent process for an established company, a duty of candor applies to you, and therefore you need to be aware and actively involved in helping to comply with this duty. Rule 56 dates back to the 1970s. In that pre-internet era, the USPTO relied heavily on the patent applicant to share background information on advancements within their respective field of technology. Times have changed. Rule 56 has not kept up. Even though the U.S. courts changed their standard for compliance with the duty of candor in 2012, the USPTO has yet to update Rule 56. Unfortunately, we still have to follow the requirements of Rule 56 to avoid the potential for your patent to be found unenforceable because we did not comply with the duty of candor. So, we must gather all of the necessary information and documentation that could be related to the patent application and then determine what non-cumulative material information needs to be sent to the USPTO. Importantly, complying with the duty does not mean that you need to do any kind of new or updated searches. We just need to know what you know about the patent application. As you're assembling your list of background information to include in your invention disclosure, here are some important things to remember about your duty of candor. The first is to explain how the invention got to the point of being the subject of a patent application, similar to showing your work on a math problem. To prove you didn't take any shortcuts, your disclosure should include all relevant information surrounding the invention. Explain how the invention got to the point of being the subject of a patent application. The way we gather information and find inspiration is always changing. Unlike the 1970s, you're rarely scanning your bookshelves for reference materials to assist in your work. Think about the digital version of what might have been on your bookshelves. Did you read a downloaded research paper for guidance? Were you reviewing a website to see how others are solving a particular problem? What do you find most relevant in understanding the background of your invention disclosure? Think of examples of relevant information that goes beyond patents, academic papers, or internet searches, such as video tutorials, notes from an industry conference, competitor marketing materials, or patents related to earlier generations of your technology. Consider whether you know any materials that may be difficult for a patent examiner to find. Generally speaking, it's safer to err on the side of disclosing potentially relevant information behind your invention to allow your attorneys to make the call. Finally, it's important to remember that the duty of disclosure lasts throughout the examination of the patent application. Potentially relevant information, even if it's found after you've submitted the application, must be forwarded to the patent attorneys or agents prosecuting the application in a timely manner. Following these steps will enhance the chances your application will be approved and will be considered a strong and enforceable patent right. If you have questions, always contact your patent attorney.